that's a possibility, and I'll let you apply that to Ernie's case. I got to kick it over to Jeff now.
Okay, so that was sort of the analysis of the traditional will contest analysis, but the line was stolen a little bit. Let's play two. And it's sort of the elephant in the room here is the new presumptively void transfers to caregivers statute that we know didn't apply in this case, but perhaps would have applied had it been in effect. So the history here is the statute 755 ILCS 5/4A was signed by then Governor Quinn in August of 2014, but it was made applicable only to transfer instruments signed on or after January 1st of 2015. So we know here the documents were signed in October. So whether that was good fortune or good planning is a matter of speculation, but I think it's worth taking a look at it under the new statute and seeing what the differences are between how the presumption of void transfer works and how the presumption of undue influence works and how they're significantly different. So just very basically, simply, maybe not so simple, what 755 ILCS 5/4A says is that anytime we have a transfer instrument that includes a gift of over $20,000 to a caregiver, and I'll define that in a moment, it's presumed to be void if challenged, period. And by transfer instrument, we're talking about any gifts that take effect upon death. So it's in the Probate Act, but it extends beyond wills. So it's wills, trusts, beneficiary designations, toadies, pay on death, all of that. But it doesn't include lifetime gifts. That's not covered by the statute. So the key to the application of the statute is this caregiver definition. So who does that include? Who does it not include? So first, it doesn't include family members of the decedent. They're totally excluded from the statute. So family members meaning spouse, parent, child, grandchild, sibling, uncle, niece, nephew, cousin. They're all exempt from the statute. We're only talking about unrelated caregivers, which is defined as a person who voluntarily or in exchange for compensation has assumed responsibility for all or a portion of the care of another person who needs assistance with activities of daily living. Now, there's a lot of words there: needs, assumed responsibility, activities of daily living. If you look at the statute for more definitions and to see what that really means, you're not going to find it. It's not terribly well defined, and at this point, there probably aren't. I don't think there's any reported cases. I don't think it's been all that teased out. So a lot of that's to come. So to get the presumption of void transfer, all we have to have is a caregiver that gets a substantial gift and a challenge. So immediately we can see how that differs from the presumption of undue influence, right? When we have the presumption of undue influence, we have to show some sort of a connection between the creation of the document and the undue influence. So procurement or participation on behalf of the alleged undue influencer. That's not part of the presumptively void transfer statute. So if the presumption of void transfer applies, then the burden will shift to the caregiver to attempt to overcome the presumption by producing clear and convincing evidence that it was not the product of fraud, duress, or undue influence. So sort of like proving a negative. And this is the second big difference between the presumption of undue influence and the presumption of void transfer. When it comes to the common law presumption of undue influence, there isn't any fixed standard as to clear and convincing standard. It sort of depends on the strength of the presumption. If there's a lot of evidence, it's a higher standard. Less, then there's left. But in any case, when we talk about the presumption of undue influence, the burden of persuasion always remains with the contestant. Not so here, right? So the caregiver has to come in with clear and convincing evidence. So we can see that less evidence is required to establish the presumption of void transfer, and more evidence is required to overcome it. And finally, on top of that, the new statute also has a rather harsh, from the contesting, from the caregiver's point of view here, attorney fee shifting provision. So once the presumption of void transfer is established, then it turns to the caregiver to decide whether to attempt to overcome the presumption or not. If the caregiver attempts but fails to overcome the presumption, then the caregiver is liable for the attorney's fees of both sides. And that's not obviously part of the typical common law. So turning back to the Ernie Banks estate here, in terms of establishing the presumption, could she have establish it if the law had been in effect? I think probably. Was Regina a caregiver? We know that he suffered that fall. I think that there was a 24-hour responsibility, the hospital said. She took him home. So then what would have happened? Would Regina have attempted to overcome the presumption, or would she have sort of given up? So I think we could see how it would have seriously affected the trajectory of the case here. So let me get a show of hands. How many of you have actually had a presumptively void transfer case come up in estate administration? Anybody? Nobody?
Under this statute?
Under the statute. Not surprising, because a lot would have to happen in a short period of time. But how many of you have had this come up, I guess the last year and a half, in an estate planning kind of a situation? Yeah, more. And I'd suggest that if you haven't, you probably will before too long. And realize it's not necessarily, whether this situation was nefarious, but it's not necessarily going to be in that kind of a situation. Think back to a client that you might have had that's, maybe they're unmarried, their closest relatives, maybe distant cousins, and so they want to leave their estate to some friends, right? So, but are those friends providing some sort of care that we don't know about? I think we have to be asking those questions now. In particular, anytime I think when we see a gift to an unrelated person, and if it's a substantial gift of over $20,000, we have to tease that out to see whether that person is providing any kind of care. And I think if we don't, it's one of those, I think it's a new malpractice trap. So now, does that mean if you have this situation that you have to just show them the door and say, hey, we can't do a presumptively void transfer? No, I don't think so. Again, it may be perfectly legitimate and appropriate. So what do you do? The statute, unfortunately, doesn't provide a good roadmap, unlike the statutes in California and Nevada, which provide a way to overcome it. It really is sort of left unsaid. So I think the key thing here is just to spot the issue, explain it to the client, and make sure you document your file just as best as possible. And my article in the ISBA is at the exhibit in here. I have a few ideas in there, but really there's nothing specific, whatever works in the situation, but just make sure you document your file if you have this kind of a situation. Dave, you want to talk about claims?